You.
Understood, Your Honor. We can do that.
Let's go ahead and do that.
Your Honor, the only thing I'd note is that our interpreter does have to leave at 2:30.
All right, so please don't take past 2:30, but I'll shift you both over to the breakout session, and when you're done, if you'll come back in, we'll finish up the sentencing.
Understood, Your Honor.
And
Your Honor, we are ready on number 38, the Dolloff matter.
all right, give me one moment.
And Your Honor, we also have, I believe Mr. Sinclair has also called back in as well, who is a morning matter.
Excellent. I think the Dolloff matter will be very quick. We'll also call on Mr. Sinclair. For our interpreter, feel free to relax for just a moment. We'll get that called back up, and we will definitely let you go by 2:30, if not well before that. Let me go ahead and call, as we're sitting here, Mr. Dolloff's matter, which is case number 38 on the docket, 20 CR 6007.
Zach McCabe and Austin Leidy for the people.
Good afternoon, Your Honor. Doug Richards and Kristen Frost on behalf of the defendant who appears on bond and is seated to my right.
Thank you. We're set today for the preliminary hearing, but I've heard there may have been some development. Where do we stand today?
Your Honor, we will be waiving a preliminary hearing. As the court is aware, this is a self-defense case. The law does not permit us to raise self-defense in a preliminary hearing, and that's something that the jury will decide in the future in this case. Therefore, we think it's probably in everyone's best interest to focus on the trial and to continue to head in that direction, and we will be waiving our preliminary hearing.
And I think that makes some sense, as you've described that precisely at a preliminary hearing, self-defense is not an issue, and I would have to even disregard information regarding that. And so when we're not having a productive preliminary hearing that's not serving its purpose, it makes some sense to say let the parties move on to actually resolving or dealing with the case. So it doesn't have to be a resolution by any means, moving toward the jury trial and so forth. Given that, I'll accept the waiver of the preliminary hearing. I think it's appropriate under the circumstances. Depending on the defense position, let me check our next position, but do the people have any record you wanted to make at this time?
No, Your Honor.
Let me check with the defense. I've had cases where we said we're ready to move ahead. We can handle the arraignment at this point, reading of any charges if appropriate, entering a plea. I've also had positions come back and say that was not our focus for today, so we'd like it set for an arraignment date. How would you like to proceed?
Your Honor, thank you. We are going to ask to set it for an arraignment in 30 days or so.
All right. Any problem with the timing for the people in terms of an arraignment date?
No, Your Honor.
We could set it for February 8th for arraignment if that works for both of you.
Just check.
Your Honor, this is Austin Leidy for the people. Would it be possible, I am set in two different courtrooms, assigned to two different courtrooms. Would it be possible to do either the week before or the week after that? I'm assigned in courtroom 4G that week.
Let me check. The 15th, the court's closed, I think it's for a holiday session, but we could do February 1st or we could do February 5th if either of those dates work for the defense and the people.
Or, Your Honor, would the 16th work?
Unfortunately, we're not in session in terms of docket sessions during those days. It's normally reserved for trials. It's not being done that time. But I can't guarantee that Judge Whitney is available in terms of that date, and he'll be handling the arraignment. So we probably have to do the Monday or Friday before the 1st or 5th if either of those would work.
Sorry, is the 19th available if they wanted to go after?
Let me check. That works as well. We could do the 19th.
That's fine with the people. Mr. Leidy?
Your Honor, that's also acceptable for the defense.
All right. We'll go ahead then and set it for an arraignment date on February 19th. Does 10:30 work for both parties?
For the defense,
it works for myself.
It works for me. Thank you.
All right. It looked like that worked on all ends. So we'll go ahead and say February 19th at 10:30 for arraignment. Let me check with the defense. Anything further today that you wanted to address today?
Yes, Your Honor. There's two matters. One, there is an agreed upon bond modification. And I don't want to get ahead of the people, but I understand that there is VRA compliance. The defendant currently is on GPS with maximum home confinement, and by agreement, that will be stepped down to just GPS.
For the people, either Mr. McCabe or Mr. Leidy, is that your understanding and agreement as well?
Yes, Your Honor, and we are in compliance with the Victims' Rights Act. I did consult with the victim about that modification.
And so I want to make sure I'm on the same page. It would take this down, I think, from the maximum level of supervision, which is effectively, as you've mentioned, in-home detention or in-home confinement in effect. And I think it takes it down, I believe, to the intensive level, which is GPS monitoring. There's certainly other pretrial service requirements in terms of checking in, but it would just be GPS monitoring. Is that what both parties are contemplating?
Yes.
Yes, Your Honor.
All right. Given the stipulation and given the circumstances, I'm aware of some of those from our prior dates, I think that's appropriate as well. So we'll go ahead and reduce it to intensive level supervision with the GPS requirements, but no requirements in terms of basically in-home confinement.
Thank you, Your Honor.
Thank you, Your Honor.
The only
Anything
other
else from
matter,
Good. Go ahead.
Yeah, the only other matter was we had filed a number of motions when we filed our entry of appearance. The people filed an objection to a discovery motion earlier in the week, and last night we filed a reply brief. My only record I wanted to make is we didn't have any further record. I know it's not on calendar for today, so I'm not asking to make arguments on it, but if the court was asking for that, I would stand on the record and I have no further arguments to make.
I appreciate that. And I'd seen that it had been filed, and in the document preparation, I had not yet read the people's response, but I can take a look at that as well. And I'm comfortable with the motion stand on their own, but I should check, did the people want to make any additional record regarding the issue?
Just real brief, Your Honor, in regards to the reply filed by the defense. And I would just point the court, People v. Velasquez is cited. It's VLASSIS 247 P 3rd 196. I think it's on point and in favor of the people's argument as to the request for notes of all investigators and prosecutor notes from witness interviews. And to a certain extent, it's also on point as to Mr. Dolloff's request for the prosecutor's emails, voicemails, and text messages between the district attorney and investigators. Additionally, Your Honor, in regard to the request for updated resumes and prior testimony here, history of witnesses, we are objecting to that. Although, as this court knows, our standard practice is to provide a curriculum vitae for all endorsed experts. Prior testimony history is not always available, and sometimes, depending on who the expert is, a curriculum vitae may not be available. The authority cited by the defense is inopposite to the material requested here, and in one instance is the Trattler case, TRATTLER, is a civil case relevant to the rules of civil procedure, Rule 26, not Rule 16 of the rules of criminal procedure. In regard to the request for exculpatory evidence, at the outset, we would note that we will comply with Rule 16 as well as Brady and Giglio, and we'll provide any exculpatory evidence. The objection to that one narrow request for prior misconduct is that some of the prior misconduct may not necessarily implicate exculpatory evidence. For example, an officer is required to wear his or her seatbelt while he is working, and if an officer somehow suffered in a department administrative action for not wearing a seatbelt, I'd fail to see how that would be relevant as to exculpatory evidence or in a case. As I mentioned, I think it's improper for us to have to provide text messages or emails for some of the same reasoning as the Velasquez court, but also as outlined in the motion. The last is a request for metadata, and we don't object. Well, we do object to that being an order of the court. I think the parties have some disagreement about what is being provided as far as metadata for the electronic discovery. So I would suggest that the parties can kind of work through that and figure out what metadata they believe is missing, because a spot check on my end showed that metadata had been provided, but there's a lot of electronic discovery in this case. So I think the parties can probably work through that and figure out what is or what is not being provided. I will state affirmatively that our office doesn't scrub any data or metadata from video recordings or electronic recordings. So it should be as we get it, and we're not affirmatively removing any information. Other than that, I will stand on the response.
All right. And that doesn't necessarily require one, but since it is the defense motion, if there's any surreply that you wanted to address in terms of the verbal issues, I'll let you go ahead.
Your Honor, I mean, most of those, the arguments that Mr. McCabe made are addressed in my brief. In fact, the Vlasis case that the people are relying on is actually prominently cited in paragraph 3 of my brief. So we seem to be on the same page in terms of the law. And in terms of the metadata, I agree that we can probably work that out amongst ourselves. We've already been emailing about some of those issues. The only reason I addressed it in the reply brief is because it was in the objection and response in opposition to our discovery motion. So with that, I think our brief stands on its own, and I would rest on the record.
I appreciate that. What I'll do is I'm going to go ahead and try to, one moment, I want to look at one thing. I'll try to get that ruling out hopefully this weekend, so it's not sitting in limbo until Judge Whitney comes in terms of that, so that you can process with the discovery. Vlasis is a case I'm very familiar with, but I want to read through the arguments both of you have made. Trattler, frankly, although it's a civil case, I retried Trattler or presided over that, so that may be the ruling from either the case I knew forward and backward, or it may have been the appeal on the case after I presided on that. So I'll look at that as well. But I don't think it's going to take a long time to get that order out, and I'll try to have that out by Monday. Other than that, I think we're in good shape. Let me just check with the defense. Anything further?
No, Your Honor. Thank you.
And for the people, anything further before we recess today?
Not for the people, Your Honor.
All right. In that case, then we'll go ahead and set this over for our next date in February. Bond will continue. The preliminary hearing, we waived at this point. We'll set it for arraignment. This will probably be my last appearance on the case with all of you. Good luck. I know Judge Whitten will be ready to go on the case, and good luck.
Thank you,
Your Honor. Honor, good luck to you.
Thank you as well.
Thank you, Judge.
Thank you.
Thank you, Judge. It's been a pleasure working with you.
Mr. McCabe, thank you as well. It's been a long time. Thank you. Let me go back to Mr. Padilla's matter, since I know Mr. Padilla is available and our interpreter has a narrow window. Let me go ahead and recall that. Let me get back to my notes. It's 18 CR 1284, People versus Christopher Padilla. Let me just check first, Mr. Smith, and I certainly would not ever force someone to make the statement, but was that an issue that Mr. Padilla wanted to address in terms of his thoughts on those options that I'm looking at?
Your Honor, it would be Mr. Padilla's preference for the year of ComCore with the credit for time served. We would be hoping that we could get a remand date and do the screening out of custody, if that's practical.
All right. What I'll do, and I appreciate that,